My crossbow. No, I think I'm gonna go turkey on this. I've been trying to sight it in.
This hearing of the Committee on Agriculture to review the Commodity Futures Trading Commission 2012 agenda will come to order. Good morning, and I'd like to thank all of you for being here. Today's hearing will focus on the Commodity Future Trading Commission, the CFTC agenda for the coming year. And I'd like to thank Chairman Gensler for joining us to share his perspective. This is a timely hearing as the CFTC is facing a number of issues of concern to our constituents. First and foremost, the CFTC's agenda for the coming year must be its investigation into the collapse of MF Global and its missing customer funds. Thousands of customers have yet to receive nearly 30% of the funds that MF Global should have held in segregated accounts. While I commend the trustee for working quickly to trace the thousands of complex transactions that occurred during the MF Global's final days, the fact remains that many customers have yet to be made whole. Farmers and ranchers across the country continue to face hardships because of their missing funds and have lost confidence in the future system. This raises several key questions about customer protections in place and the CFTC's role in futures markets. Although the CFTC has gained new authority over the swaps market under the Dodd-Frank Act, the MF Global collapse demonstrates the importance of CFTC's oversight responsibilities in futures markets. In addition to our concerns about MF Global customer funds, we also must address the Dodd-Frank rulemaking process. As the CFTC nears the halfway mark in completing the dozens of regulations required by Dodd-Frank, I remain concerned about the breadth of those proposals. Instead of focusing resources on the entities and activities that pose the most significant risk to our financial systems, the CFTC is casting a wide net that could needlessly catch end users. For example, for months we have been assured by Chairman Gensler that the swap dealer definition would not result in unnecessary regulations of end users, which Congress never intended to fall within the swap dealer category. However, as the Commission neared completion of the rule last week, end users were frantically seeking clarification that their hedging activities would not be classified as swap dealing. Now, this doesn't make sense because Congress never intended for hedging to be considered swap dealing. Additionally, the CFTC has yet to propose a rule that would clarify the scope of its new regulations for activities that occur outside our borders, what we refer to as extraterritoriality. There's a long-standing precedent by both the CFTC and the prudential regulators to defer to foreign regulatory authorities in matters concerning foreign entities and transactions. Expanding the reach of the Dodd-Frank into activities outside our borders not only ignores the principles of international law, but it spreads our agencies and resources too thin. It also threatens the international cooperation required by for global financial reforms as envisioned by the G20. Additionally, the lack of clarification on the territorial scope of regulations has made it incredibly difficult for market participants to prepare for compliance. The confusion over the swap dealer definition and the foreign scope of those regulations are just two examples of many issues which the CFTC has failed to deliver concrete answers or policy solutions. Our constituents need more than empty reassurances. Most of these concerns are rooted in an issue that we have discussed for more than a year now, the need for strong and robust economic analysis. The Economist magazine recently highlighted the Obama administration's tendency to overstate the benefits of regulation while underestimating the cost. That has certainly been apparent in the Dodd-Frank rulemaking. At a public meeting recently, CFTC staffers admitted they simply had not calculated the cost and benefits of a rule governing internal business conduct standards. They could not provide substantive analysis for the conclusions they drew about how the rule would impact our economy. And that's unacceptable. Even if the CFTC was attempting to conduct economic analysis of Dodd-Frank regulations, it would be difficult given the lack of clarity about which organizations will be affected by each rule. Making policy without regard to the economic consequences is a luxury we cannot afford, even in the strongest of economies, and we certainly cannot afford it right now. I look forward to hearing Chairman Gensler's agenda for 2012. But more than that, I look forward to a time when we can guarantee our constituents that they will not be overburdened by regulations and that were not intended for them. And with that, I'd like to recognize the ranking member for any opening comments he might have.
Thank you, Mr. Chairman, and welcome Chairman Gensler back to the committee for today's hearing. In addition to passing a farm bill, oversight of the CFTC has been a top priority of this committee, and I think it's important for Chairman Gensler to provide an update on the agenda of the CFTC for the year, along with the Commission's progress on implementing the financial reforms passed in 2010. Looking at the Dodd-Frank rules that have already been finalized by the CFTC, I believe it's safe to say that so far the CFTC has done a pretty good job. And in my conversations with Chairman Gensler, it seems to me that they are on the right track going forward. For example, during a legislative hearing last year, we heard concerns about business conduct standards and potential impact that they could have on pension plans' ability to use swaps to hedge risk. In January, the Commission approved a bipartisan final rule establishing business conduct standards. And in the general feeling I get from the pension plans is that the CFTC got the final rule right. As the CFTC continues finalizing more rules, I suspect that they will continue to get it right and address the concerns that we have heard at various hearings. I know that some have expressed frustration with the CFTC's process for implementing these reforms. While it has not been a perfect process, we cannot lose sight of the importance of their taking the time so that they can, in the end, get the right outcome. But the CFTC has more on its plate than just Dodd-Frank. It is still in the process of investigating what happened at MF Global and monitoring our futures markets as we watch energy prices continue to climb. The Commission does these things and much more, all the while being grossly underfunded. Today's hearing will provide members with an opportunity to ask about these and many other issues currently before the CFTC, and so I look forward to hearing Chairman Gensler's testimony and thank the Chair for holding today's hearing.
The Chair appreciates the gentleman's opening comments, and the Chair would request that other members submit their opening statements for the record so the witness may begin his testimony and to ensure that there's ample time for questions. With that, I would like to welcome to our witness table the Honorable Gary Gensler, Chairman, the Commodity Futures Trading Commission, Washington, D.C. Mr. Chairman, please begin whenever you are ready, sir.
Good morning, Chairman Lucas, Ranking Member Peterson, and members of the committee. I'm pleased to be here also with my fellow Commissioner Jill Summers as well. Today, I'm told it's my 39th time testifying before Congress in this job. Apparently, I've been in the job 109 days, but I will tell you this is the first time I've testified on February 29th. So, yeah, there you go. After a full 2011, the CFTC has significant work in front of us for 2012. Derivatives markets are critical for farmers, ranchers, producers, and other end users in the real economy. And as this committee has noted to me, but I would give the statistic, the non-financial side of our economy provides 94% of private sector jobs. That's what the derivatives markets helps. This group, through futures and swaps, allows these companies to manage risk and focus on what they do best. That's servicing customers, producing products, farming, milling, and investing in our economy. My written testimony is more complete, but in short, our agenda includes completion of the swaps markets rules, clearing mandate determinations, which is a big piece of what Congress gave us, implementation of swaps reforms, working with members of the public on that, enhanced customer protections, and adapting oversight to changing market structure. Last summer, we turned the corner from our proposal phase to starting finalizing rules. We've completed 28 rules to date, and we have just over 20 to go. While the statute generally called for us to complete this within 1 year, it's taken us longer. And we're completing rules in a thoughtful, balanced way to get them right, not against a clock. And with 28,000 public comments and 1,300 meetings with the public today, there's a lot to consider. We are close to finalizing rules with the SEC to further define the term swap dealer. I believe we will be responsive to comments from farm credit institutions that have been a subject of some of your discussions here and bills, agriculture cooperatives, and yes, to commercial end users and the issue the chairman raised about hedging. The product definition rules should follow later during the spring. But again, we're not trying to rush these. We're trying to get them right and listen to the commenters in this committee. We also are looking to soon finalize the commercial end user exception. Our proposal took Congress's intent to heart. Non-financial companies using swaps to hedge or mitigate commercial risk, they're out of the central clearing, and we also proposed it was their choice whether to margin, that the banks couldn't force them into the margining regimes. I also want to mention that we are taking the legislative proposals of the committee into consideration as we complete our rules. I view them as pretty serious comments in our comment file. The Commission, for example, has already provided for certain exceptions for inter-affiliate swaps from real-time reporting and the external business conduct rules that the ranking member mentioned. We also look forward to seeking public comment on inter-affiliate clearing for financial companies. As we finalize reforms, we also have reached out broadly on how to best implement them, including last year's roundtables, public comment periods, and many meetings. And I thank you, Congressman Conaway, because we've worked a lot with you on thinking this through. In response to this public input, we've included phased implementation in many of our rules. We're also working internally to implement the swaps reforms. The Commission published a new strategic plan last year. We've restructured some divisions, in particular standing up a new data and technology division. And given our increasing oversight needs, we're investing in updated market technology. Before I close, I will mention resources. At about 700 people, we're only about 10% greater than we were in the 90s. And since then, of course, you've asked us to also cover the swaps market, which is nearly 8 times the size of the futures market. And though the CFTC is not a price-setting agency, rising prices for basic commodities, agriculture and energy, just remind us once again of the importance of having effective market oversight that ensures the integrity and transparency of these markets. I'll conclude just by saying that the derivatives reforms, once implemented, will benefit all Americans in the real economy. They will benefit the end users of derivatives, which are responsible for most of the job creation in the economy. It will do this through the transparency and competition it brings to the marketplace. I think also it will benefit the public by lowering risk that Wall Street poses to the rest of us. I thank you, and I look forward to your questions.
Thank you, Mr. Chairman. The Chair would like to remind members that they'll be recognized for questioning in the order of seniority for members who were here at the start of the hearing. After that, members will be recognized in order of arrival, and I, as always, do appreciate the members' understanding of that. And I now recognize myself for 5 minutes. Mr. Chairman, you've recused yourself from the investigation of MF Global, correct?
That's correct, that I'm not participating in that matter, sir.
And you have not been involved or privy to information regarding new developments in the investigation and relevant enforcement proceedings, correct?
That's correct, sir.
Chairman, you do plan on being involved in any policy response that the Commission makes based on the lessons learned from MF Global. For example, the Customer Protection Roundtable scheduled for the next 2 days. Correct? You'll be involved in those?
I've, for a long time, sir, focused along with my fellow commissioners on customer protection, was involved last summer and last fall when we tightened up the investment of customer funds protections in December, when we, through the clearinghouse rules, ensured that margin should be posted on a gross basis. And as consensus develops, to the extent consensus develop, would anticipate being involved in some of these matters of general rules.
So as I understand it, it's your intention as the Commission moves forward on proposals potentially as early as this spring. So I guess my question would be, Chairman, how can you be in a position to lead the Commission in the policy response when it should clearly be supported by and lessons learned during the investigation if you're not a part of the investigation?
Well, you're right, sir, that I'm not part of that investigation. But as I mentioned, there are a number of things that the Commission laid out even before the matters of the fall, like tightening up the investment of customer funds. To the extent that a consensus forms through these 2 days of roundtables, through a lot of market input and market feedback, I would be involved in that as one of the 5 members of the commission. And I do believe that there would be significant public input on anything and reaching any changes in the rules to really help the public and enhance what, as you said, is a core foundation of the futures and swaps markets, that customer money is protected.
But you would acknowledge, not being involved in the day-to-day investigation going now, the lessons that hopefully will clearly come from that process does make it more challenging for you to be a part of the solution.
Well, I think of this, if I might, somewhat as an incremental. I think what we did in December was very critical to tighten up some of the loosening that we had frankly done in the earlier years to the investment of customer funds. I think what we've done in the clearinghouse rules are very critical as well. But again, as a consensus forms, and I don't know what will come out of these 2 days of public roundtables, but we've asked the public to weigh in. The public is also not participating in the investigation, nor am I.
Chairman, over the next several months, you've reassured this committee that the definition of swap dealer will not result in end users unnecessarily having to register as swap dealers. Yet last week, it was your intention to propose the final rule related to swap dealers, and the end user community was frantically working to have an explicit exemption for hedging included in the rule. Chairman, it was, of course, never Congress's intent for the Commission to consider hedging activities to be swap dealing. In fact, Congress made every effort to ensure end users are exempt from clearing and margin, which are only 2 of the many regulations associated with being a swap dealer. If you intended to make improvements to the rule, as you have reassured us, and members, me and for that matter, and members of the committee, then why were end users forced to make last-minute appeals to commissioners for help on something as fundamental as the classification that hedging is not swap dealing?
I think we've done a good job throughout these rulemaking to take into consideration public comment, but I will say that normally speaking, in the last 2 to 3 weeks before we vote on something, we hear from people reminding us of their comment letters, even sometimes when we've taken already and adjusted the base text of the rule, because these documents are not put out again under the Administrative Procedures Act. With regard to the actual rule itself, let me speak to the substance. One of the key things in the rule, if I might say, is market making, that if there's 3 or 4 prongs that Congress laid out. If you're regularly engaged in swap dealing is one of them, but another one is if you're market making. And we got a lot of comments to narrow that, to address that, and I think that we will address that, particularly with regard to the words hedging.
I guess the question, Chairman, is, based on your assurances in the past and the near panic that was set off over this definition issue, how can the committee be assured that assurances given today won't lead to near panic on other rules as the process goes along?
Well, I think just as the ranking member mentioned on the pension fund issue and external business conduct, I remember some pension funds being in our building, and it's on our website, 2 and 3 days before our rule. I mean, we are running a very open process, and I welcome the commenters coming in, but I'm saying that there's a number of issues on the entity definition that you and I fully agree on, is that the end user community are not swap dealers. There are some parties that have chosen to deal, that make markets on a routine basis in the energy swap area. They actually list themselves as primary members of the International Swap and Derivatives Association, which says you can only be a primary member if you make markets not for hedging. And that's really the approach. It's not, I think there's not a difference between you and I, sir, on this issue.
With the indulgence of my colleagues, one last question. Chairman, would you say that you're coordinating with your international counterparts as required by Dodd-Frank in Section 754?
Yes, very much so. We share our draft documents with them before we consider proposals and finals, but more than that, we meet with them extensively. Commissioner Summers and myself both. She was just recently in Japan. I'll be over in Basel and Brussels next week.
Chairman, I understand that the European Commissioner for the EU on this subject matter, Michael Barnier, just last week, would have said in regards to the U.S. And its efforts of coordination, and I quote, "It is not acceptable that U.S. rules have such a wide effect on other nations and foreign capital markets without any international coordination. A unilateral approach is a path to fragmentation and inefficiency. We need more international cooperation in all of these areas. This is a message I would bring to all of my U.S. counterparts. Think internationally." How do you respond to that?
Michel Barnier and I had a very good meeting last week. His letter was, I think, specifically about the Volcker rule, which he and I had a lively discussion on. That's a very difficult rule and challenging because Congress gave us two pieces: prohibit one thing, proprietary trading; permit another thing, market making. But we've had an ongoing dialogue with Michel Barnier and his people, was at one point weekly, where we looked at gaps and overlaps. And as I say, I'm going to meet with him again next week on Tuesday. So it's been a very constructive coordination, a partnership with.
But Chairman Gensler, my understanding of Commissioner Barnier's comments were not limited to the Volcker rule. In fact, they were much broader than that. And if leaders of one of our primary partners in the global regulatory reform, the EU, is concerned that we're taking a unilateral approach to reform, yet you're telling us you're working closely together, there's clearly a lack of coordination here and apparent inconsistencies with what you've told the committee. International cooperation coordination is a key to making global reform effective and to ensure that we're not unnecessarily building inconsistencies or duplications in the regime that will hamper competition growth. I just urge you to more carefully consider the feedback from our global partners. And with that, Mr. Chairman, I thank you, and I yield to the ranking member for 5 minutes.
Thank you, Mr. Chairman. I think everybody should understand that hundreds of millions of dollars have been spent over the last year or two by these folks trying to get around these rules. And, I think some of the concerns are legitimate and some of them aren't. But, from what I can tell, kind of where you're heading with the commission is that if you are actually hedging, you're an actual end user, that's not going to trigger this swap dealer designation. But there's certain of these firms in the electricity area and in the energy, gas and oil area that are actually dealers, like you say. And from myself as one of the sponsors of this bill, those folks, the dealer part of their business should be regulated. So that's what I think, and I don't know, I guess you guys are sorting through that, but, what it looks to me like some of the end users are trying to convince members that we're somehow or another trying to do something to them on their end user status to get out of the other part of it where they're clearly dealers, So I hope that, we get more of this out into the public so people can understand what's going on. There's been a lot of noise made over all this stuff. And on this the issue, it looks like a combination of this extraterritorial, whatever it is, and Volcker, that some of these folks are using the old saw that they're going to move their stuff overseas and so forth. We've heard that. That's part of why we didn't regulate people in the first place. And I just hope people understand that a lot of what's going on here is that people still don't want to be regulated. They still want to do whatever they want, what got us in trouble in the first place. And, so I, for one, hope that you look carefully at this. And, from what I understand, the end users that are actually hedging for commercial purposes are probably not going to be swept up in this. Is that?
I agree with that, and the way that we can address that is because Congress laid out one of the prongs to be a swap dealer is market making, and so we can modify in the final rule to clearly address. That's really about routinely accommodating people knocking on your door to hedge their risk, not your risk.
Yeah,
somebody else coming.
They're actually competing in the same market as these big Goldman Sachs and J.P. Morgan and so forth, right? I mean, they're in the same market.
There's a small handful. For the tens of
Yeah,
thousands
but I mean,
of users
there
of
are
this, they're
people
not
that are-
going to be caught up in this. But
Right.
there are some who have chosen actively to deal. The largest integrated oil companies, some of them have dealing desk, and they do because that's a business they choose to be in and provide liquidity to others.
Yeah.
But they also regularly, it's set up as a regular business.
Yeah, I know.
And that was another prong, that if they set it up as a sort of a regular business to provide that liquidity and risk management, again, to others.
And it wouldn't be fair to the people that are being regulated to have their competitors not be regulated. I mean, that seems to be,
Well,
they're actually in the business.
I think it's that, or we could look back to 2012 and then we would call it the BP loophole instead of the Enron loophole or something, frankly. I mean, I think there are very real bylaws of the International Swap and Derivatives Association that says you can only be a primary member if you make markets and not for hedging.
Right.
And there are 6 or 8 companies that have voluntarily they choose to do that. Now maybe they'll stop choosing to do that, but and it's just really to make sure, as you say, that the tens of thousands of end users, I agree with the chairman, if they're entering into a swap, foremost, if they're not routinely, like daily, making markets accommodating demand to somebody else, they're not a swap dealer. But secondly, if they're entering into swap really, and the purpose is to hedge the energy that they're producing or the oil they have in the refinery, that's not accommodating somebody else's business.
One other thing, Mr. Chairman, if I could, we've heard various reports from folks that have met with you and other commissioners. These rumors are circulating constantly that one of these rumors is that there is some interest in the commission of exempting high-frequency traders from the definition of swap dealer. Until 3 years ago, very few people outside of Wall Street had even heard of high-frequency trading, and there are some indications that it may have contributed to the flash crash in May 2010. So I would have concerns about such a blanket exemption. So is this under serious consideration at the commission? And if it is it wise?
It is something that some high-frequency traders have come in. They actually sometimes tout that they make markets. They don't yet make markets in swaps, but if they were to develop to make markets over the next several years, I think it's consistent with congressional intent that if you're making markets actively accommodating demand in the markets, that you would register. So I think it would be unwise to somehow just leave them out now, they wouldn't be necessarily coming under, let's say, the sales practice regimes or external business conduct, because in January we made sure that those rules don't cover people anonymously trading on a market. But you're correct. Some of them have been making the rounds. Some of them actually came in. One came in this week and said they look forward to registering. They think they're registered in other jurisdictions. So it's actually, even amongst that community, a split community.
Gentleman's time has expired. The chair now recognizes the gentleman from Iowa for 5 minutes. Mr. King.
Thank you, Mr. Chairman. Chairman, thank you for your testimony and the repeated testimony here on the Hill. I understand that you've recused yourself from MF Global, and I don't want to press anything on that. I just want to ask just a very standard question. I think that could be reviewed from just reading the papers. But if they had not been switching between accounts to keep themselves liquid for the day, is it a safe conclusion that they would have gone bankrupt sooner? And if so, how much sooner would you guess?
I don't know. I think this might be when I turn to Commissioner Summers.
Sure.
Congressman, I'm not familiar with the press reports that you're referring to, but I guess I would say that our current investigation is doing just what you indicated. We're tracing those transactions out of the customer segregated accounts to find out where they would have gone. I don't know at this point whether they would have gone bankrupt sooner.
I'll just say that from where I sit, and I'll just make this comment then, and you can decide whether you'd like to answer or not. From where I sit, if they hadn't been using segregated accounts to meet their daily call, then I'm just going to, my position would be that they would have collapsed sooner and gone into bankruptcy sooner. That's an observation from what happens when you run into a cash flow problem. I thought that was a simple, basic question. So that's my comment on it. And if you choose to disagree, that's fine. But I don't want to put you on that spot. I'd like to instead move on a little bit and direct to the chairman. I have information in front of me that says that of derivatives, well, first, maybe I better ask this broader question. Do we know the value of derivatives and the value of swaps, total notional value of each?
We have approximations. The futures market runs in the U.S. between $35 and $40 trillion, depending upon the month and the time of year. The total worldwide size of the swap market is reported. It's a little over 700 trillion, and it's estimated a little less than half is here. So I usually use an estimate of 300 trillion, but it is just that, an estimate.
Okay. Well, thank you. That gives us a sense of the scope of this. And I've got data in front of me that shows that 96% of the value of the derivatives in this country are in the hands of the 5 largest banks, or in control of the 5 largest banks. And then if you go to the top 25 banks, you're at a 99.86% of those, the notional value of the derivatives. And we've got a little over 1,000 small institutions that are trading there in that 0.14%. And I'd like to know, is your intent to regulate those small banks in the same method as the larger banks?
No.
Are you concerned? Oh, good. What would be your intent?
Congress gave us a flexibility to set a de minimis in the swap dealer definition, and we put out to comment a de minimis that many commenters came in and said was too low. And so it's under consideration between the Securities and Exchange Commission and us, but I think we've taken those comments to heart. Worldwide, there's between 35 and 40 large banking enterprises that are currently clearing at the London Clearing House, the big interest rate clearing house. Most of those have indicated they'll probably register. But then when you get beyond that group, depending again where we end up on a couple of key definitions, the de minimis, and also something I'll likely be asked about lending in connection with or swap dealing in connection with originating loans, I think that those thousands of banks will not be at all touched.
Would you have an estimate on how many banks would be? I went to 25. That number it sounds to me like it'll grow, but would you have an estimate on how many banks would be covered?
I don't sitting here, but the 35 to 40 international banks, some of which aren't in the U.S., that are registered with that clearinghouse are the types of banks that are likely to register.
So the small institutions have breathed a sigh here, I think. But I'd like to go to...
That's our goal, sir.
Yes, and I'd like to go to Dodd-Frank. And if this Congress did the sweeping thing, and perhaps not this year, perhaps in the next Congress, and repealed 100% of Dodd-Frank, what would be the impact from your perspective?
I think the public would lose the benefits of transparency and competition in this market, this 300 trillion or so notional market. I think end users would they might not feel it immediately, but the next time Wall Street spills out risks, they'd look back and say, that wasn't such a good thing to repeal Title VII. I'm just speaking about what this committee came together to do. I really think the public would be more at risk. Let's not forget 8 million jobs were lost because of largely the financial community's risk spilling out to the economy in 2008.
If I could just conclude with this, Mr. Chairman, and that is that sometime back in 2007 or perhaps in the late fall of 2006, when we were first looking at these shifts that were taking place financially that brought about this downward spiral that we're reacting to now. I remember a conversation with an investment banker who said then, what you do when you're in this business is pretty much what everyone else does. That way, if they're making money, you're making money. And if things fall apart and there's a bailout, you'll be bailed out with the rest of them. I make that statement because I wrote that down that day. I remember it clearly, and I think it was the precursor to what actually happened. I think our investors in this country, many of the large institutions, were counting on a bailout. I think they knew they were running on the edge and taking those risks, and the bailout came. That prediction came true. So I just incorporate that into the process. There's two ways to do this. One is let the investors take the risk and evaluate the collateral. The other one is to do the regulatory and the expensive thing that has not been proven by the Obama administration. Appreciate your testimony and the response of the commissioner as well, and I yield back the balance of my time.
Gentleman's time has expired. The chair now recognizes the gentleman from Pennsylvania for 5 minutes.
Thank you, Mr. Chairman, and Chairman Gensler, thank you for being here. I agree with the ranking member's opening statement that so far in the rulemaking process, the CFTC has been, really attentive to concerns that have been raised. I just have one question about farm credit, though. Last month, this committee passed in a very bipartisan manner H.R. 3336, Small Business Credit Availability Act. Among its provisions, this bill reaffirms Congress's original intent that farm credit institutions qualify for the statutory exemption we provided in Section 1A of Dodd-Frank, which states, in no event shall an insured depository institution be considered to be a swap dealer to the extent it offers to enter into a swap with a customer in connection with originating a loan with that customer. At a previous hearing, you raised a question as to the Commission's ability to ensure that farm credit institutions would be able to get this same exemption granted to insured depository institutions. Do you still have those doubts, and do you believe the Commission has the authority to grant farm credit banks this same exemption?
I do believe that we have the authority. The hearing was helpful. I don't remember how many months ago it was, and there was a member over here that asked it, but I can't remember whom.
Yeah.
And we went back and researched it. I think we do have the authority. And though the American Bankers Association recently sent us a letter and pointed out they thought otherwise, so there are comments on both sides of this. But
Okay. Thanks, Chairman. Yield back, Mr.
Gentleman yields back. The chair now recognizes the gentleman from Texas, Mr. Conaway, for 5 minutes.
Thank you, Mr. Chairman, and Mr. Gensler, welcome to the committee. I'm going to return to a topic that's near and dear to my heart and yours as well, I suspect. I feel a lot like Sisyphus pushing this rock up a hill and it rolls back down and pushes it back up. And that's cost-benefit analysis that the Commission, in my view, needs to do on each of its rules. As you know, we've passed a bill here that would strengthen 15A of the Commodities Exchange Act prospectively. Wouldn't have to go back and redo it for these. But recently, two of your commissioners have been pretty critical of the cost-benefit analysis that's been done, particularly with respect to the business conduct rules, examples of 1-year retention on audio conversations that need to be taped with the technology may or may not be available, a 15-year retention on documents with respect to swaps, a duplicative requirement on retention of documents that the swap data repositories in accordance with your rules would be required to maintain as well. Overlapping requirements. Can you talk to us about why that is cost effective and or necessary that these duplicative costs need to be put in place under the business conduct rules?
These rules, Congress said that records have to be kept, including voice recordings. That's statute. We got a lot of comments on that, and we actually moderated. We rolled back in the final and said the voice recordings no longer have to be digitized or put on an electronic file. And in fact, with Commissioner Amalia's help right there on the dais, we even rolled back a little bit more, and we assured people all you have to do is keep it and make sure that if the enforcement folks request something, that you can search it. And there's a lot of software to search it by keywords. You could search it by Congressman Conaway or something. And so I think we clarified that. To the second question about keeping books and records, books and records are important, whether it's in the future securities or now swaps area, so that a company can manage its risk and even report to its public shareholders, and to have a check actually on the clearinghouse or somebody else. So, no, we did come out that they have to keep internally books and records and don't, so to speak, outsource that to somebody else in their general ledger and subledger.
Part of your analysis will be then to check
records against records?
No,
swap dealers,
not that we.
SDRs against the internal documents? We're going to run into that?
It's just that they have to keep books and records on their transaction and trading so that they can manage their credit risk, manage their interest rate risk.
I understand
and
that. That's all done while that trade is active. I got that. They're going to do that anyway. 15 years when most of your other records retention requirements are 10. Why the 15-year retention in this area?
I'd like to get back to you just on that, if I might, because
Okay.
I don't remember the retention.
Let me ask you something else. And this came to our attention just within the last day or so. Single-family offices where they are doing a lot of things for really wealthy families have enjoyed an exemption under the rules. SEC has recently given them an exemption from certain rules. Are you willing to work with that community to make sure that they're treated the way they've been previously with respect to Rule 413A3? To make sure that they can do their business without unnecessary regulations and new layers of cost to these families?
Yes, but even further than that, I think there's 4 exemptive letters that we've given over the last 10 or 15 years, and we said affirmatively that those would apply, as a general matter. But again, there's always things that are different. So
yeah, the
yes.
concern, though, is under the commodity pool operator rules that exemption that previously was there was not included. You may be of oversight, but you're willing to work with that community?
Oh, absolutely. But the 4 letters, there were actually letters. They weren't in our rules. So those letters then can be relied on by other people in a similar circumstance. It's more a question whether it's a little bit different circumstance.
All right.
And that's where we'd like to work with that community.
All right. Well, Mr. Chairman, I continue to be concerned that the cost-benefit analysis that's either there or not there is not representative, and there may be other ways to get at some of these regulations and do what the, excuse me, young man, staffer, excuse me, that the industry reactions and their responses to these things, that the cost benefits associated with what we're doing make sense. So with that, Mr. Chairman, I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Connecticut for 5 minutes.
Thank you, Mr. Chairman, and thank you for holding these hearings, and Chairman Gensler for your endurance. These are really important issues. And coming from Connecticut, where my local gas station hit $4 a gallon last week, again, the importance of the work your commission does is in people's faces every single day. I mean, the data that we're seeing, that's widely reported in the media, that supplies are higher than they were 3 years ago when gas was $1.90, that demand is down from where it was a year ago, and yet we're seeing this spike happening in February of all times of the year at a moment when our recovery is finally getting some traction. Again, to me, just underlines the need for the commission to move forward on what the Dodd-Frank bill mandated. I mean, I've been reading the pleadings in the court challenge that somehow suggest that you exceeded your discretion by imposing these position limits last October. That is ludicrous. The law is crystal clear that this is something that the commission was required to do, and not just to do it, but to do it expeditiously. I mean, frankly, there are a lot of folks in my state who are upset with the fact that it took so long for the commission to extract a rule. And I'm not pointing the finger at you. I realized you had a juggling act in terms of trying to line up 3 votes on that commission, and you did it, and I salute you for it. But obviously, we're 5 months out since that vote occurred, and yet there's still no rules in place, again, with all of the negative trends that we're seeing reemerge. Again, the very issue which the Dodd-Frank legislation was intended to address. So, number one, I mean, if you could give us an update, because people are anxiously looking to you for relief here in terms of where we stand as far as the implementation of the October rule.
I think you refer to the position limit rule, and that rule would go into effect after 2 important things: that we finalized jointly with the SEC the further definition of the term swap, the product definition rule. We've made good progress, but as you've seen on the entity definition, we've scheduled that once and rescheduled it a couple times. So I would think the product definition rule is this spring, to give you a realistic time frame. And secondly, the collection of 1 year of data. We started collecting that data last fall, and I think the year runs through this August, if I'm not mistaken. But it was also needed 1 year of data to collect and then apply the formulas. And of course, as you noted, there is this court challenge on the core question that, of course, I think you and I agree. I think if there's ever clear congressional intent, this was, I mean, people talk about intent on end users and intent on the Farm Credit Bureau, but if there was ever an intent, I think the position limits this committee had spoken of a number of times from 2008 on.
Well, I know Commissioner Chilton issued a statement a couple days ago, again, acknowledging the fact that you were able to muster the votes to get that measure through last October. But frankly, time is the enemy here in terms of trying to get a market that is transparent, that has some connection to supply and demand. And again, I would urge you and I wrote to you a few days ago on this specific point, to get those position limits, to follow the law, which is what, the Congress enacted. This committee tried to trip up that law with H.R. 1573. Luckily, it has not moved forward the 2-year stay on the Dodd-Frank legislation, but the impact in terms of small businesses, individuals, consumers, the payroll tax cut extension, which we just passed a few days ago, is just going to go up in smoke, literally, at the gas pump. And it's just critical that we get these rules in place. I don't know if you wanted to.
Well, I was just going to say, I think some of what we have done has been very significant. We will have brought greater transparency to these markets by this summer when reporting has to begin in these markets, energy swap markets included in them. We've passed very strong rules unanimously, if I recall, on anti-manipulation to give us new authorities to chase after folks that are manipulating markets. So I think we have done some very good and constructive final rules that are in effect, take some time to implement, but you're correct, the position limit rule takes a little longer.
And lastly, the impact in terms of government spending as far as these price increases in terms of our military dwarf whatever your budget request is that came in. And again, I hope that this Congress will recognize that you've got hard work to do and that you need the staff to do it to protect our economy. And I'd yield back, Mr. Chairman.
The gentleman yields back. The chair now recognizes the gentleman from Arkansas, Mr. Crawford, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, for your appearance today. Just want to ask you, in your decision-making process, why have you chosen not to convene the Ag Advisory Committee since the grain, hog, and beef industries have been so severely impacted by the MF Global meltdown?
We consult with members of the Ag Advisory Committee pretty regularly. Some of them are even participating in this 2-day roundtable that was referred to. The actual formal meeting of the committee for the last number of years, I think 6 years, has been once a year. We're only in February, but we're certainly going to bring that together as a formal group and have a public meeting. We did have Commissioner Dunn, who so successfully chaired it for years, retire, and so we also have to find a way just to move forward, but absolutely committed, and we use members of the committee as much as we can and seek their advice.
Do you have a timeline on that, when you might convene that just yet, or?
I don't, because believe it or not, it's a little bit also working with the General Services Administration, just because how charters have 2-year clocks and things like that. But I'd be glad to work with your office and get you more details.
Okay, thank you. Of course, ag co-ops, for example, provide swaps to their members and then enter into another swap to offset that risk. This is critical to their ability to continue to provide hedging tools to members of their co-ops. In that scenario, would the offsetting swap make an entity eligible for the end user clearing exemption?
Well, I think that, I hope as we finalize this, we've spent a lot of time with the agriculture cooperatives around the dealer definition again, and if it's an agriculture cooperative that's Capper Volstead and dealing with another co-op or one of its members, it's almost like an inter-affiliate transaction. I think we've worked through an approach subject to commissioners at 2 commissions voting on it, that they're not going to get caught up in the dealer definition. To your question then, if they're not a dealer, they are an end user. I mean, they're just then by definition an end user.
Okay, would the offsetting swap meet the definition of a hedge of commercial risk?
Well, I think they would be an end user if they're not a dealer, so any of their swaps, they'd have a choice whether to come to a clearinghouse. And under our end user exception, that I think is what you're referring to, the proposal, I believe, would be a yes to that. If that's, I'm trying to follow the question, but I think you're referencing to the, would they be exempt from clearing if they choose to be? And I think the answer is yes.
Okay. Let me switch gears to small banks real quick. Out in the country, it's important for many farmers and ranchers that they be hedged against commodity price risk in order to qualify for loans from their local banks. Relationship between commodity hedging and borrowing is exactly what Congress intended to preserve in the swaps in connection with loans exemption from the swap dealer definition. Will community and mid-sized banks that provide commodity swaps to their loan customers be eligible for this exemption under the final swap dealer rule?
We've received comments. We're still looking at it. Again, I think, as I mentioned to other members, because of how we're addressing ourselves to the market-making definitions and the de minimis definitions, those community banks to which you refer, I'm not aware of any that will probably be above some of these numbers. But there may be. I'm not suggesting there might not be one or two.
Okay. And finally, in the little time that I have left, if the commodity swaps that small and mid-sized banks provide to loan customers are not covered under the swaps and connections with loans exemption, continuing to provide those swaps will make them swap dealers and subsequently subject to Section 716 push-out provisions. So my question is, has the CFTC examined the impact within the context of the swap dealer rule?
We're aware of it. It's part of our discussions. Again, I think that as you refer to community banks, particularly because there's an interplay between a de minimis, how high to make that, the definition itself of market making, in essence, how tight to make that. That, as I said earlier, I think the community banks, I mean, if there's one that you specifically know of and your staff wanted to share with us, it'd be helpful to understand the issue better.
All right. Thank you. Yield back.
Gentleman's time as gentlemen's yield back. The chair now recognizes the gentleman for Vermont for 5 minutes. Mr. Welch.
Thank you very much, Mr. Chairman. Thank you, Chairman Gensler, for being here. I want to talk a little bit about gas prices and the speculation premium. I have an article from Forbes that basically goes through a Goldman Sachs analysis that says that there is likely a $23.39 speculation premium in the price of a barrel of oil if oil is at $108 a barrel, which when this study was done it was at. What it talks about is that the positions on NYMEX for future contracts is the equivalent to 233 million barrels of oil, which is the equivalent of 1 year's crude supply from Iran to Western European nations like France, Belgium, Greece, Italy, and Spain. And it goes on to do an analysis in the Careful Goldman way to state that if there is a $23 a barrel speculation premium, that translates into about 56 cents per gallon of gas. And obviously that has a brutal impact on our consumers, and it has a brutal impact on many of our manufacturers that depend on petroleum products. Also, this is happening at a time when our production is high, our demand is relatively low, and the United States is actually exporting gasoline. Do you have the resources that you need to address the speculation premium that is now injected into the price of gasoline at the pump and that is doing so much harm to our economy and so much damage to the pocketbook of everyday consumers?
Well, I'll take a broader question. Do we have the resources we need? No, because Congress just gave us a large task. I hope that once we finalize these rules, which I anticipate most will be done by this summer, there'll be a handful that will take longer, that we can move on and work with this committee, work with the appropriators, and get the resources to move the agency to close to a 1,000-person agency from 700-person agency. I do think that rising energy prices, as a reminder, is why this is a good investment to the American public.
All right, so I mean, the point of our legislation, I think, was to acknowledge that the futures market is absolutely essential for end users, but that to the extent it's manipulated by Wall Street speculators, it's for their benefit at the expense of consumers in the productive economy. Is that a fair statement?
Absolutely. We're a good investment for the real economy. The real economy is 94% of the jobs in this country, and I sometimes feel that people are trying to tip the scales back to Wall Street through our rule writing.
Do you have any reason to dispute the analysis by Goldman Sachs as to how much of a price is being imposed through speculation as opposed to supply and demand?
I don't. I know it's been quoted by many. There's other analyses that say other things, but I don't have things to either support it or deny it.
All right.
To support or deny Goldman Sachs's analysis, I just don't know.
All right. Now, many of us have supported legislation that would provide a steady and stable funding source for you, not you so much as your agency, to do the work that needs to be done on behalf of consumers in the productive economy, much like the SEC, a small fee on transactions. Is this something that would be helpful to make certain that your agency had the resources that it needed to act on behalf of consumers and the productive economy?
The president included reference to this in his recently sent budget to the Hill. I think prior presidents of both parties have raised it. I would support whatever this committee and Congress thought would help ensure that we have the adequate resources, whether it's out of the general treasury or fees. I'm supportive either way. And if this committee would like to work on it, I'd work with you on it.
Well, I thank you, Mr. Gensler. And Mr. Chairman, this seems like an area of common interest because all of us represent consumers who are getting hammered. We represent Democrats in Republican districts, and we represent Republicans in Democratic districts. And every one of us has been hearing from families where they're just wondering why, if the demand is going down, the price is going up, and how in the world they're going to pay for this. And it's hurting our manufacturers as well. So if there's any way, Mr. Chairman, that we can find our way clear to help get the price down, I think we ought to do it. I yield back.
Gentleman's point is appreciated. The gentleman yields back. The chair now recognizes the gentleman from Illinois, Mr. Holtgren, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Chairman Gensler, for being here today. I apologize. I had another committee, so I had to step out for a few minutes. So if any of this is repetitive, I apologize, but are important questions from my constituents that I wanted just to ask and see if we could get some answers for. One is I'm just concerned about the continued delays in rulemaking process that are creating regulatory uncertainty and affecting the ability of especially rural electric and farm co-ops to plan for the future, especially with regard to pending definition of swap dealer. After several apparent delayed votes on that rule, I wondered if you could give my constituents any idea of what to expect, when to expect it, specifically wondering what your prediction is for the de minimis exception and where that will be set.
I'd like not to get out ahead of not just my commission, but the SEC. So it's 10 commissioners deliberation, and you're right, we had hoped to vote on this, and then there was more collaboration over at the SEC to go on. But in terms of the de minimis, higher than where we were without pinning myself down, because it's 10 commissioners weighing in. And that with regard to the agricultural co-ops, as we've said, we've worked a lot with the community, with this Capper-Volstead community offering risk management through swaps to their members. We're going to do our best to try to treat that like it's an affiliate situation. And then on the rural electric cooperatives and municipal power authorities, we've been working, I think it's now for 6 or 8 months. We're hoping that they'll come in and file a petition. We've been working actively with them. And then we'd put it out to public comment and get what's called a 4C exemption. But we have to vote on it, put it out to public comment, and then finalize it. We're doing something similar with the regional transmission organizations. I hope we're close to them filing the actual petition, but we're not there yet.
So the delay is their filing, or is the delay from your office?
On the rural electric cooperatives, I just want to say we've been working very cooperatively, but yes, I mean, we need because that community is so diverse, in fairness to them, to put this petition in front of us does take some coordination between a lot of actors in their community. I can't speak for other commissioners, but I'm personally supportive of it.
What's your best guess? Is it 30 days? Is it 90 days? Is it 120 days for that specifically? And then also, talked about dealing with the 10 members of, waiting for them to respond.
With regard to the finalizing the definitions, the entity definitions, it is my hope, but I can't tell you it wouldn't slide. It will be through that this coming month, March. With regard to the cooperatives, the rural electric cooperatives, if we could get back to you, but I was hopeful that we were going to have a petition in February, but I think, I don't want to speak for them. If the petition came in, then we'd put it out to public comment. And so I'd say it's probably well into the spring, time, by the time we start to get the public comment, and that, I believe, takes 30 days as well.
Okay. Again, I wasn't here for all of the debate on Dodd-Frank, but I'm wondering just a little bit. I know this. Getting back to the de minimis exception, the $100 million level to start with. Was that ever realistic? It just seems like such a low number, and opens it up to so many questions out there again for my constituents. And just wondering again if there's a recognition of what I see as just an unrealistic number, and hopefully a realization that it's.
We've gotten a lot of comments. You're absolutely right on this, from whether it's community banks, end users, and we're taking them very seriously.
Okay. And maybe, again, you've already discussed this a little bit, but we've been hearing a lot of questions about this as well. And with commercial hedging, wondering if that will expressly be excluded from the activities that constitute swap dealing under the rule.
Congress laid out a number of important prongs. Market making is one of them, and regular business is another one, if I might say. And so a lot of commenters came in and said, well, what's market making? Can you be more specific about that? And in my mind, I'm just speaking in my mind, it's really about routinely making yourself available to others who need to hedge, not about your hedging. It's about routinely making. So it's not about some energy company that the purpose of what they're doing is hedging, the oil in the refinery. In terms of regular business, we got a lot of comments about that. Can we be a little bit more specific and explicit about that? And again, I don't want to speak for other commissioners, but in my mind, I think there are things we can do there to help people out. And then, of course, address the de minimis. Sometimes that's just an easy way to help folks, realize.
Well, hopefully it can be both, because I think both create that uncertainty and continue that. So my hope is that it can be well defined. And from what I'm hearing from you is you're pretty much saying you don't have control of it. We would probably argue you've got a little bit more control.
No.
I
understand.
We want to make sure that we're getting that assurance that again that this isn't, that there is going to be some express exclusion of commercial hedging, and again, people who aren't in the business of that, but just are in the business of trying to serve their customers, to run a business, and knowing the uncertainties of agriculture and commodities markets.
I think that we will sufficiently address the issue of hedging in the context of a producer or merchant who, that's your point.
Good. Well, I look forward to seeing that. So thank you very much. I yield back.
Gentleman's time has expired. The chair now recognizes the gentlelady from Ohio for 5 minutes. Ms. Fudge.
Thank you so much, Mr. Chairman, and thank you, Chairman Gensler, for being here. I just have two brief questions. You may well know that Congressman Steve Stivers and I introduced H.R. 2779, which is a bill that would exempt certain inter-affiliate transactions from swap dealers from meeting margin and clearing requirements. This would ensure that transactions are not classified as separate transactions. If these contracts are classified as separate transactions, there is a concern that it will increase the cost for customers of the products, and it will impede the ability of businesses to manage their risk. I have two questions. The first is that you talked about it as well as in your testimony. You state that the final rules will include exceptions for inter-affiliate swaps. Is that going to be in that group that's coming in this summer, or when is that?
Well, some of them have already been completed. For instance, in December, we completed the reporting rule, and I know in your bill, I think you addressed reporting as well.
Right.
This is the public reporting or real-time reporting. So we addressed affiliate swaps there that are not really arm's length transactions and so forth. We addressed in January in the sales practice or external business conduct where we said, again, these affiliate transactions that aren't at arm's length so forth shouldn't have to, protect the sales practices in that regard. In most affiliate transactions, if one party is an end user, there will not be any clearing requirement. But what we think we need to do is probably publish for notice and comment, and we believe we have the authority to do it, but publish for notice and comment between a financial company and its financial affiliate, where both are financial companies. That's the one area. So for the end user community, they don't have, I truly don't believe that this is an issue. But it's just, within an insurance company between two of its affiliates, for instance.
What do you think that time frame is?
I think to put out a proposal on this, given our calendar, it's going to be likely in the spring, and then we have to put it out. Maybe we'll decide only to put it out to 30 days comment instead of 60, because sometimes where there's more consensus, we might go a little shorter. And then try to, again, this whole area, we have about 20 or so more rules, adding an inter-affiliate, adding others, maybe there'll be 25. As I say, we'll be working through the summer and fall possibly on some of these.
Okay, thank you. And the second part of my question is, I understand that the SEC has suggested that they will treat these transactions differently than you may. Can you discuss how you plan to address the concerns of market participants when they may have to comply with two different sets of rules on the same product?
We spent a lot of time with the SEC in trying to harmonize and sometimes advocate for our point of view on the trades between affiliates. I have not been brought, it's just not brought to my attention, but if your office could help me, if there's something that you think the SEC is not doing that I should know about, I'd like to help you on that.
We'll certainly be in touch. Thank you. I yield back.
Gentlelady yields back. The chair now recognizes the gentleman from Nebraska for 5 minutes.
Thank you, Mr. Chairman, for holding this important hearing. Chairman Gensler, welcome. What's causing the rise of the price of gasoline?
I'm spending so much time thinking about enhancing customer funds and working on these rules. But we're not a price-setting agency. It's not what Congress asked us to do. We're an agency that oversees the markets to ensure that they're transparent, competitive, and free of fraud and manipulation. And so that's what we can best do to ensure that these energy markets work and that whatever price, high or low, in the energy markets and the agriculture markets reflect buyers and sellers, both hedgers and speculators, meeting in that market.
Right. Here's what's at issue. If you look at demand for gasoline, in fact, you see lower demand currently. Supply disruptions, perhaps volatility in the Middle East are a factor, but not significant enough to probably correlate directly to this spike that we're seeing currently. Back to Mr. Welsh's question earlier, it's been suggested by your own commissioner in a recent article, Bart Chilton, that there is a speculative premium built into the price of gasoline that may be as much as 56 cents per gallon. Do you agree with that assessment?
I agree that we need to make sure that our markets have a strong oversight, that we have a strong anti-manipulation regime, that we have transparency, and yes, that we complete position limits. That's where Commissioner Chilton and I are very much aligned.
These current speculative position limits would adequately address the problem?
I think that the whole regime, I must say, I think that the limits are one part to ensure for integrity of a market, but I think that it's critical that we complete the other rules with regard to transparency, that we actually give the public the benefit of this whole work that this Congress did and that we are now about a year late on.
What would you surmise the correlation to be between the Federal Reserve's loose monetary policy as driving down the value of our currency, therefore increasing commodity prices, particularly oil, which tends to lead the other prices? What is the correlation there? In other words, our debt, and the way in which we're printing money to solve it, lending itself to higher commodity prices as a major factor in this uptick of retail gasoline prices?
I've not seen a study on the
I haven't either. That's why I'm
correlation.
asking you, but we're trying to examine all of the factors here that are involved. I
Right.
mean, something's doing it.
You're absolutely correct. But if I might return, I think our role as a commission, as an agency, is not to set a price or even that a price is low or high. It's
No,
really to
I
make sure the
understand.
markets are transparent and work for the
I
American
understand. You're
public.
just an expert in the dynamics of these markets, so it'd be helpful to hear your opinion as to all the factors that are driving up the price in this regard.
Though at any one time there are many factors, I'm not aware of a study, and if there is one, I'd certainly read it and so forth. But on the specific point that you mentioned about the monetary policy and so forth,
Could be a factor.
Well, there are many factors that come into markets. These markets, to just give you a sense of the oil market today, and we publish these figures every Friday, has producers and merchants, and that makes up between, I think, 13 to 15% of the open futures market. And there's swap dealers that makes up a big group, and then the managed money, that's the hedge funds, and then other financials. So somewhere between 80 and 85% of the futures market are swap dealers and what we call managed money or hedge funds and other financials, and 13 or 15% of the futures markets, this is on the NYMEX and so forth, are the producers and merchants.
How has that ratio shifted through the years? It used to be inverted, is my understanding.
We've only been breaking out this in the four categories. We started doing that about 2 years ago, and we published, I think, 5 prior years. So over those 7 years, it's shifted a little less than you said, but yes, it's shifted
Significantly.
a little bit more towards
Speculation.
financial.
I'm about to run out of
participants.
time. I'm sorry. I'll interrupt you right quick. I think the broader point here is we're deeply concerned that a system originally designed to mitigate risk is actually creating risk now.
Well, I think that that's just a keen reminder as to why we have to continue to get our oversight right, and also that we need to be a fully resourced and funded agency.
Thank you. I yield back.
Gentleman's time has expired. The chair now recognizes the gentleman from Georgia, Mr. Scott, for 5 minutes.
Thank you, Mr. Chairman. Welcome, Chairman Gensler. Chairman Gensler, let me ask you, the whole core of what we're trying to do rests on funding. We can write all kinds of laws. We can put all kinds of regulations. Dodd-Frank is a tremendous, tremendous bill, law, very complex, and it puts a tremendous responsibility on your agency as the regulator. So I need to know, and I think the committee needs to know, the American people need to know your real serious thoughts on the funding of it. And I specifically want to ask you, if you do not have sufficient funding, could we see delays in reviewing, for example, applications for new swap execution facilities, designated clearing organizations, and swap data repositories?
I thank you for that question. The answer is yes, we could see delays. We're about a 700-person agency, and with the help of this committee in Congress, we have $205 million of funding. But that's only about 10% more staff than we had in the 1990s. And though I deeply respect you all have a very hard job with the appropriators, we are asking, along with the president, for funding to move up to $308 million, a little over 1,000 people, 300 more people, because we're taking on a market 8 times the size. We do not right now have what I would consider a plan that's adequate to address all the registrations that will come in. We expect between 20 and 30 swap execution facilities, a handful of data repositories, 2 or 3 more clearinghouses. We're going to rely on the NFA to register dealers. We're probably going to borrow some of our enforcement staff and move some enforcement staff for 6 months or so to try to deal with some of these registrations. But that's not, I would call that that's a backup plan at best. It is the plan we have, but it's not a plan that I think is the best for the American public.
And this would also apply to delays in reviewing swaps to see if the clearing mandate should apply, requests for exemptions to the law's provisions as well.
We're hopefully, the clearinghouses will start the review of mandatory clearing this spring, but you're absolutely correct that when people knock on our doors for interpretive letters, no action letters, exemption petitions, this is a human exercise, and we do need more technology, but the computers can't just take an exemptive request and put it in one end of the computer and it prints out the other end.
That's very important, and I think that we owe it to your agency if we are drafting these major pieces of legislation, which are needed. Certain tweaks certainly need to be made here and there, but there are forces at work that don't like Dodd-Frank. There are forces at work that find creative ways of trying to do away with Dodd-Frank, and there's no more clearer way of accomplishing this than starving the very agencies and the regulatory people we assigned to do the job. It's sort of like cutting the legs out from under somebody and then condemning them for being crippled.
Well, though I would have to say to you, Congressman, I believe working with my fellow commissioners and an excellent staff, we will get the rules finished, and then the industry will want people there. Right. But you're right, we will not have the people even to examine the clearinghouses on an annual basis, on a regular basis.
Let me ask you, I had 1 minute to go, and our ranking member brought up an interesting subject of extraterritoriality. Hope I pronounced that long word right. And it's also an issue that you and I have discussed in my other committee, Financial Services. It's my understanding that the SEC Chairman Shapiro has announced that the SEC will issue a formal rulemaking related to the extraterritorial application of the Dodd-Frank law. Can we expect the CFTC to also issue a formal rulemaking on the extraterritorial scope of the Dodd-Frank as the SEC has announced?
Though our statutory situation is a little different, we will seek public comment on what is called 722D, or it might be called 2I of the Commodity Exchange Act. They don't have that provision, but that's basically the core to this question. In addition, I'm hoping to get public comment through that release on swap dealer where we defer to foreign regulators. We have a long history of deferring to foreign regulators. I'm hoping that we can continue to do that, but that will be also in hopefully get public comment on it.
Thank you very much, sir.
Gentleman's time has expired. For the benefit of the members, it's worth noting we'll next go with Mr. Schilling, followed by Mr. Boswell, followed by Mr. Hulskamp, followed by Mr. Thompson, and finally Mr. Tipton. With that, Mr. Schilling's recognized for 5 minutes.
Thank you, Mr. Chairman. Good to see you again, Mr. Gensler. As you know, Congress provided an exemption for captive finance affiliates from both the definition of a major swap participant as well as the definition of financial entity for the purpose of end user clearing exception. The statutory language, however, leaves room for interpretation by the Commission, and the operational realities of the financing provided by captive finance companies require additional clarification from the CFTC with regard to how they intend to interpret the calculation of the 90/90 rule. For example, take a tractor made by John Deere in Moline, Illinois. The tractor may have an implement that's not made by John Deere. Are they allowed to finance this transaction?
Though I'm very familiar with the provision, and we will carry out the intent of this committee in Congress on the captive finance provision, I'd like to sort of work with staff and get back to you on the specific question of the, I think if I follow the question, is if John Deere sells a tractor, but there's an implement that they sell with it.
Right. Like let's say they sell a tractor and then they've got an auger that goes with it.
Right. Right.
Are they going to be able to do that, basically.
Well, I know they'll be able to sell it, but your question about, because the provision says that 90% of what they're financing has to be what they're manufacturing, if I remember.
Right.
And so it's a question of whether the auger, because it's not something they manufactured, would be counted against the 90%.
Exactly.
I think I think that our proposal didn't speak negative or positive to it, but I know this question has come up, and I don't know how we'd address it other than in a facts and circumstances. But certainly, if I can talk to staff afterwards and get back to you.
Yeah, that'd be great, because as I understand, many of these companies are already hearing from the other folks that they do business with, and they will demand assurances that these captives qualify for the exemption before they will, trade with them. So it's just another piece of certainty. I think that the John Deeres, the Caterpillars, and other companies out there just really need to have some good, solid clarification to where it's not going to be second guessing by you guys. So very good. With that, I yield back my time. Thank you, sir.
Gentleman yields back. The chair now recognizes the gentleman from Iowa, Mr. Boswell, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Chairman Gensler, for your work. It seems to me like if we just give you the tools and get out of your way, you'll get on with it, and got lots to do, and it's kind of holding you up. But we keep discussing it, and this is not a criticism, Mr. Chairman. This is just discussion. It seems like half of our hearings have been about this subject, full committee, and probably as much on the subcommittee. And I'm sure you'll have something to say, but I'll yield to you momentarily. I understand and I support the need for congressional oversight, but I believe we must get to other business too. And I'm concerned about the Farm Bill. Many of us have experienced the hands-on, you and me, and we know the plan. We've got to have a little information to plan ahead. And you probably know things I don't know about this Farm Bill, so I just hope we get to it. I think it's important. And I know you do too. So you might comment on that. Another issue, Mr. Welch touched on it, and this Forbes report about speculation, the cost per barrel.
Yeah.
Now, I've spent a lot of my life in Texas and a lot of my life in Oklahoma, and I know what those arms going up and down mean. I see them and all over the place, even I believe at the state capitol grounds in Oklahoma. It used to be. I understand that. I'm not quarreling about that. But I just feel like that this gasoline price impact on our producers, economy, everything about it, that we owe it to our people that we support, that they have other options as well as they go about planning their business and not rely on OPEC and Wall Street. So could you comment on some of that for my ratification, my clarification, or whatever?
I would just, and the gentleman yields, and I appreciate that yield to the fine gentleman from Iowa. I would note, as far as the Farm Bill goes, this is one of those issues where, as the pieces come together, we'll move as aggressively together as we possibly can. Whether it was last fall in the hurry-up effort for the super committee, where the chair and the ranking member worked very diligently with the chair and ranking member of the other body to try, in a time frame that was very tight, to craft policy. Unfortunately, the rest of Congress and the super committee didn't match the efforts of the House and Senate Ag committees. Whether it was that scenario or the situation we're in this summer, we're going to do everything within our power, working with every member of this committee in regular order, to craft that good farm policy and move us forward. As far as the number of hearings that this committee's dealt with that relate to Dodd-Frank and the Commodity Futures Trading Commission, I just simply observe that the very aggressive rulemakings process that the Commission's gone on, mandated by Dodd-Frank, has the potential for tremendous effect on the economy, not just agriculture, but the entire national and international economies, and doing our responsibilities of oversight, looking over the chairman's shoulder on a regular basis, asking the chairman lots of pointed questions on a regular basis is a part of our responsibility, and I believe that helps he and his fellow commissioners do a better job in their important role. And we'll continue to work that. I won't deny to you for a moment that when all of this is done, and all the rules are in place, and hopefully everyone agrees on the same interpretation. If we never have another CFTC hearing as long as I live, it'll be too soon. But that said, until we reach that magic point, we're going to do our job. And I would also note to my good colleague from Iowa that very soon we'll announce a series of hearings in the field addressing Farm Bill issues. I suspect after that there'll be a few more hearings here in this very committee chamber addressing Farm Bill issues. And we're going to load our quiver, we're going to sharpen our blades, and we're going to get after that Farm Bill, sir.
All right.
Thank you for those questions.
Well, thank you for the reassurance, and thank you, Mr. Gensler, for your work. I know we gave you a lot of responsibility, that a whole volume of rules to come up with and so on, but appreciate your work and the time that you've had to spend answering questions to me and so on. Thank you for that, and I wish you continued success. And Mr. Chairman, thanks for your remarks. But speculation, I think, is going on. I don't know if we'd agree on that or not, but I think we probably do. And I do think we do agree that we have responsibility to do everything we can. I know we agree. Everything we can to let our producers out there know they've got what they got to deal with. Thanks for your efforts. Appreciate it. I yield back.
And the only comment I would add is just let it rain in Oklahoma. With that, I thank the gentleman, and he yields back. And I now turn to the gentleman from Kansas, Mr. Schulskamp, for 5 minutes.
Thank you, Mr. Chairman, and I appreciate the opportunity to visit with you, Mr. Chairman, as well. And I know in one of your previous answers, you said your main priority, your top priority, was enhancing customer funds. And I want to follow up with a few more questions. I know you were unable to make our hearing in November on MF Global, and I understand. And these questions will be directed before you left to recuse yourself from the investigation. And so I'd like your comments that, given that 99% of MF Global's accounts were commodity accounts regulated by the Commission, do you think it is appropriate the bankruptcy was structured as a SEPA bankruptcy, thereby stripping customers of their priority status?
If I might just try to answer it as a general question about when futures commission merchants under our jurisdiction and regulation are also broker-dealers under the Securities and Exchange. There's the bankruptcy protection of SIPA, the Securities Protection Act, and there's the bankruptcy protection, which is in the Bankruptcy Code, and so forth, and they interact. But as I understand it from my knowledge of this from staff, is that once it's a joint broker-dealer futures commission merchant and there are securities customers at risk, the way the law interacts is that the Securities Commission and SIPA can put it into a SIPA trustee. The good news, though, from what I understand, is everything that's in the Bankruptcy Code to protect the futures customers, subpart 4, I think it's called, or our code rules 190, they have to use those same provisions.
But customers with segregated funds that were lost, they did lose their priority status. Is that correct with this approach in bankruptcy?
I might have to turn to Commissioner Summers because it's about this specific matter, but I don't know if I'm able to sort of.
I've got a couple of the questions as well, and Ms. Summers, if you would answer that question, I'd appreciate that.
Of course. Thank you, Congressman. In this SIPC proceeding for MF Global, commodity customers have an exclusive right to the customer property that were in the segregated accounts. They did not lose their priority status in that particular bankruptcy case.
Okay. All right. Thank you. Second question would be, Mr. Chairman, I guess, given it was obvious on October 31st, and I know you weren't able to make our November hearing, I guess, on this issue, it was obvious by then from the details that we've seen that customer funds were missing and likely commingled. Why didn't the Commission move immediately to freeze the assets of MFGI and MFGH with that knowledge in hand on October 31st?
I'll try to answer just that, what I know about from that weekend. I think that's before I was not participating. But just from what I know about that weekend, the company, MF, had filed that they were in compliance each day, and that weekend, most of that Sunday was the company, not us, were working to move the customer positions to another company, Interactive Brokers. And so there was a series of conference calls on that Sunday to help facilitate the movement of that. And as it's been widely reported, it was somewhere around 2:30 in the morning that I was woken up and told, no, that's not the case. And then a few hours later, the protections of SIPA and the bankruptcy court were put in place.
Put in place on what day?
At
2:30 in the morning? The same day?
Well, no,
Sunday?
they weren't put in place until whatever, I don't know if it was 6 or 8 hours later.
Okay, so you had no knowledge, or no one at the commission had knowledge before that, that there was commingling of funds occurring?
I can only speak to what I know of.
Well, yes, that's why I'm asking you the question. I want to ask anybody else because you're the head of the commission.
No,
this is
but
10 days before you were recused.
I was woken up around 2:30 in the a.m. on the 31st of October.
And did they tell you funds were commingled at that time?
To be more precise, I was told that there was that the account was. I don't actually remember the words, but the word that you used was not used. It was just that the.
Well, tell me what word they used, please, if you would. If you can remember. We're talking about billions of dollars. I know we're talking about 2:30 in the morning for you, but these are billions of dollars for farmers and ranchers that have been lost.
Absolutely, I recall being woken up and saying, being informed with a lot of people on a phone call, international regulators, the SEC, and so forth, that the customer fund account was not, that the deal with Interactive was off and the customer funds account was not whole.
So there was customer funds missing, and that's what you were told?
I don't recall the exact words, sir.
Okay, and Mr. Chairman, if I might, for just 30 seconds, just trying to think, if I can just figure out, then could you provide for the committee what you were told at that time? At a later moment, and again, this is 10 days before your recusal, or whatever you are, a non-participant investigation.
I don't want to, I want to work with this committee, but also not prejudice an ongoing investigation of the career staff and so forth as to, so
you won't tell us what you were told then, Mr. Commissioner?
No, I want to work with this committee but it's also what was told to any representative of the CFTC over that weekend, and I was a representative of the CFTC, is also a matter of an investigation as well. So
are you personally being investigated?
No.
Is that why?
No,
okay,
no,
so,
it's just a fact.
So I want to ask you as a member of the committee that you will tell us in writing if necessary what exactly you were told at that time of the day.
And just working with the committee and the Division of Enforcement.
Well, I don't care about the Division of Enforcement. This is a request from myself as a member of this committee, and I'm not asking about the division, and I would just like to know what you and apparently dozens of other folks were told. So thank you, Mr. Chairman.
Gentleman yields back. The chair now recognizes the gentleman from California for 5 minutes.
Thank you very much, Mr. Chairman. Good hearing this morning, and I have several questions. One, California specifically related. Last hearing on the markup of H.R. 3527, you may or your staff may have informed you that there was a California-specific issue that Congressman Baca and I raised at the time to the chair and the ranking member on California's ability for our energy providers to comply with our unique regulatory system, and that under the changes it might qualify California's energy companies as swap dealers. The utility companies have submitted comments to the CFTC. There's been extensive discussions with your staff. We've seen no positive, at least I've been told that there's been no positive movement on the issue. Later today, I'm going to be sending you a letter to more thoroughly outline my concerns, and hoping you might be able to speak to whether or not you believe actions that have been undertaken to comply with state or local laws or regulations should be specifically included in terms of what is determined as to whether or not an entity is a swap dealer or not.
I'm trying to recall the hearing to which you're referring. Is this related to the municipal power authorities in Los Angeles and elsewhere?
Well, it's related to the major utility companies in California, PG&E, Southern California Edison, San Diego Gas and Electric. We have a deregulated environment under which they purchase and under the definition, under the HR 3527, they may be viewed as a swap dealer, and they don't believe they're swap dealers. But obviously, this issue has not come to your attention.
Well, there were two California issues because the Municipal Power Authority of Los Angeles.
This is not municipal power
I
authorities.
just wanted to distinguish.
It's needed to ensure that these companies and ultimately California ratepayers are not charged the additional fee on this issue.
So I believe that we'll successfully address through the entity definition rule that, as Congress said, if somebody is making markets, it's only if they are accommodating others on a routine basis, and that I'm not familiar enough with PG&E's business.
Please get familiar with it and get back to us. I'm going to send you the letter this afternoon. We don't want, because these California companies are complying with state law, to be penalized by the federal regulators that ultimately could impact the ratepayers in California.
I think they'll benefit by this law because it will bring transparency, and I believe that will address your...
That's the larger issue, but there is a problem. Get this, there's a problem with complying with state law, regulatory law, and we need to work through that problem.
I look forward to reading your letter.
Okay, thank you very much. On the broader set of issues, and it's been talked about before in terms of the impacts on gas prices and the volatility and the potential speculation, while they're talking about the potential to reach $4 a gallon, they've exceeded $4 a gallon in California. I was at the pump on Saturday, and it was in excess of $4.18 a gallon as I saw my fill-up reach almost $70. So we're aware of the BP fire in Washington State on the refinery, but other places in the West are being similarly impacted. We know from the data on the Energy Information Administration that the supply, as has been already stated here this morning, of oil and gas is higher today than it was 3 years ago when the national gasoline was at below $2 a gallon. We know it's a worldwide market, of course, but right now the demand for oil in the U.S. is the lowest since 1997. I would like you, I'm not satisfied with the response you've made earlier this morning as to whether or not you agree that something else more basic than supply and demand is driving these prices.
These markets are made up of hedgers and speculators, and at any given time, it's both are part of a market. As I mentioned earlier, in fact, the futures market is over 80% of the market is swap dealers, hedge funds, managed money, other financial.
So you would say
less than 20%.
Speculation is having some impact. You just can't quantify it.
On any given day, financial actors, as you are referring to them as speculators, are part of the pricing of energy and agricultural products. Our role is to make sure and ensure that that market is free of manipulation, it's transparent, and it reflects supply and demand.
Well, my time's expired, but Chairman Gensler, the fact is that for American farmers and all that benefit from the products that we produce, the CFTC has taken and is undertaking with other authorities to address the extensive energy speculation that's doing it. I don't know if you care to comment any further as to what specific efforts you're taking under the new Dodd-Frank rule.
Well, just that it's the broad rules. It's new anti-manipulation authority. It's transparency authorities. It's trying to complete, once the data is in, position limit authority. So I think it's really the collection that this committee asked us to address the markets with.
Mr. Chairman, I wasn't here earlier, but is it the desire of the committee to have the commissioner to come back and report when they've made their findings, or to provide it in some informative fashion?
I believe that is certainly possible, and that can be addressed as one of the questions submitted to him, and a response to that would be the report. I thank the gentleman from California. His time's expired.
Thank you.
I now recognize the gentleman from Pennsylvania for 5 minutes. Mr. Thompson.
Chairman Lucas, thank you. Chairman Gensler, thanks for coming once again. You had mentioned in your testimony the time constraints for completion of the rules, and that the CFTC is, quote, completing rules in a thoughtful, balanced way, not against the clock. Well, how specifically is CFTC allowing for flexibility with rulemaking?
Well, foremost, Congress gave us 1 year to complete, which was last July. And of course, here we are 8 or 10 months later. We put out exemptive order last July to say the whole market could rest at ease until December. And then again, we came back in October and November and said rest at ease again until this coming July. In addition, in each of the rules, we have phased implementation. And in some cases, it goes out years. Some cases, it's just months. It depends on what comments we've heard from the markets. I would be hopeful that we would complete most of our rules by this summer, but as I've said in my written testimony, some might take longer. We want to get these things right.
One of the things I see just burdening our economy is uncertainty from many different aspects. And so what's your agency doing to help relieve some of the uncertainty that many of our banks and financial institutions are experiencing as these rulemaking processes continue?
You raise a good point, because it's balancing lowering that regulatory uncertainty with not trying to rush things. And I think this committee wants us to do both, but I've taken the chairman to heart not to rush things. So, but as we complete each rule, I think we do help lower that uncertainty. Beyond that, what we have tried to do is really reach out and have a lot of work with market participants before and after a rule is done, through roundtables, and then, as we've done in some of these data rules, to actually have weekly calls with market participants to sort through some of their questions. In one case, we put out an over 100-page topic area on large trader reporting to help describe how to get the data in.
You mentioned in your testimony that a motive for the current expansion of regulations that you believe failure to regulate swaps in future markets led to the 2008 financial crisis. Could you please describe a specific regulation that you've added since the 2008 financial crisis that significantly reduces the risk of future financial crisis?
I think in a number of places. I do think swaps were not the only cause of the crisis, but it was part of it. I think the overall regime of clearing and central clearing lowers the interconnectedness, and I think we'll get this right. This committee in Congress wants end users out, but the other part of the markets to be in clearing. I think transparency, even what we completed in December, starting this summer in July of this year, regulators and market participants for the first time will actually see the pricing of these transactions. It will be delayed to protect the anonymity, to protect the market, but people for the first time will start to see what the pricing of these transactions are.
One of the critical pieces of the mosaic of regulations that you describe in your testimony is the definition of a swap. Could you please share with us your preliminary definition and indicate areas in which you think changes are likely?
In the definition, did you say swap or
swap?
Swap,
please.
Swap. We've gotten a lot of questions and comments, which I think were very helpful, just drilling in on where forwards would not be considered to be swaps. And I think it was the intent of this committee. I know there was a colloquy, an important colloquy, then Chairman Peterson on this matter, on that forwards aren't treated as futures and they're not treated as swaps. I think we'll give, hopefully, my hope would be we'd give greater clarity on that whole topic. There's similar topics that people have raised concerns about when insurance is not a swap, when regular commercial transactions are not a swap. So I think the final rule will benefit from those comments and clarity.
Okay, thank you. Chairman, I yield back.
Gentleman yields back. The chair now turns to the gentleman from Colorado. Mr. Templeton, for 5 minutes.
Thank you, Chairman Lucas, and thank you, Chairman Gensler, for being here. Chairman, we're very aware of the importance for agricultural producers to be able to gain access to credit, and quite often an important component of their ability to gain that access to credit is to ensure that they're hedged against the risks they face, whether commodity prices or be it interest rates or currency rates. In recognition of this, Dodd-Frank provided an exemption for banks that provide swaps in connection with loans from designation of swap dealers. To ensure the important relationship between risk management and the flow of credit that can continue between small and mid-sized banks and businesses. This link, I believe, was well described in a letter by one of the banking regulators from the OCC that they sent to you last year, expressing their concerns with a narrow approach to the swaps in connection with loans. The exemption is proposed by the CFTC and the impact that this may actually have on our banks. The OCC, and I'll read this, stated specifically in their letter, the statutory language does not limit the loan exclusion to swaps that are connected to the financial terms of a loan, nor does it require that the swap be entered into contemporaneously with the loan origination. CFTC's proposed implementation of the loan exclusion effectively prevents community and mid-sized banks from offering commodity-based swaps to loan customers. We're concerned that this interferes with the bank's risk management and believe that it was precisely this type of risk management that Congress intended to preserve through the loan exclusion. Loan underwriting criteria for the community and mid-sized banks that offer loans to commercial customers engaged in a commodity-driven business may require, as a condition of the loan, that the borrower will be hedged against commodity price risk incidental to its business. This hedging activity reduces the bank's credit risk on the loan since the borrower is situated to withstand potentially volatile commodity price fluctuations. They did continue on in regards to the restrictions on the timing of the swaps relative to the origination of the loan. In their letter, they stated, the loan exclusion should also be implemented in a manner that recognizes the practical reality of bank and end-user risk management practices. To that end, the loan exclusion should be tailored to allow for ongoing hedging throughout the life of a loan, providing such hedging is connected to the origination of a loan as discussed above. Eliminating the exclusion to swaps that are contemporaneous to loan origination or close thereto, as is contemplated in the proposed rule, would preclude ongoing risk management connected to bank lending and increased credit risk for bonds. So, familiar with that. And Mr. Gensler, in light of the fact that one of our primary banking regulators expressed concern that precluding commodity swaps from the exemption or by placing arbitrary timing restrictions on swaps in connection with loans will actually raise credit risk at our banks, can we expect these restrictions to be omitted from the final rule?
I'm familiar with the comment letter and other comment letters about lending in connection with originating a loan. We're taking them all into consideration. We actually asked questions of the public on a number of these issues. Let me just focus on one, the second that you raised, as to what does it mean in connection? Is it contemporaneous? Is it a week before? Is it a month before, et cetera? Is it throughout the life of the loan? We got a lot of different, there's a range of feedback on that. And we'll be addressing all of the issues, I think, in that controller's letter. Some of them will bring added clarity, but again, subject to other commissioners and to commissions. I'd say the other piece of this is...
I'm not sure, not to interrupt, but I'm going to run out of time. I'm not sure I'm hearing an answer to the question. Can we expect that to be omitted from the final rule? Because the primary purpose of Dodd-Frank was to be able to lower that risk.
I'm answering as best I can that in an active rulemaking that we will take into consideration, and I'm very familiar with the controller's letter and his other letters on other topics. John and I sometimes talk about these letters as well, and I believe the community banks also will ultimately understand that as we address ourselves to the de minimis as well, that's going to be something. But I'm not able at this stage to say that we're accepting the controller's letter completely.
Okay, you aren't willing to accept that, but you said you were reaching out to the market participants, and they're directly saying, with the backup of the OCC, that this is going to raise that risk.
Again, sir, it's the banks who offer swaps in connection with originating loans have raised questions about when can they give that. We're going to address that as best we can, those comments and the comments of the controller, and address the comments separate from that letter about the de minimis.
Great. Well, Mr. Chairman, if I can just have about 30 more seconds here.
Pretty quick seconds.
I appreciate that. I would really applaud and stand behind Mr. Costa in terms of his regard to be able to bring these back to committee, because I think the legislative intent is incredibly important. And as you're developing these rules, and I would join myself and associate myself with Mr. Holtkamp's remarks as well in regards to actually having a response back to his request. So,
Gentlemen,
thank you.
time has expired. The chair will now turn to the gentleman for final questions from the Republic of Texas for 5 minutes. Mr. Nogelbauer.
Thank you, Mr. Chairman. Chairman Gensler, good to have you here today.
Good to be with you,
I think
sir.
it's been mentioned that Commissioner O'Melia last week strongly criticized the final swap dealer business conduct rule, saying that he felt like the commission had failed to really do a comprehensive cost-benefit analysis of that rule. And I think, in fact, in some of the discussions with some of the CFTC lawyers, they really couldn't produce any substantial numbers to indicate that really any kind of cost-benefit analysis had been done. And I believe Mr. O'Melia asked the OMB for independent review of that process, and to see if whether those rules comply with the Obama administration's executive orders. In fact, I think he used the word that y'all had committed regulatory malpractice. That's a pretty strong statement from one of your commission members. And I think one of the things that many of us are concerned about is we've been tracking the compliance, just the compliance side of Dodd-Frank. So it has about 400 different rulemaking requirements. I think we reached a milestone the other day. I think we're at 140. I think you said that you've done about 25 or 26. You had 20 more. So that means we're 1/3 of the way through this process. And the current number is that it takes about 21 million man-hours to comply with the first 140 rules. Now, I want to put that in perspective for you. It means that it only took 20 million man-hours to do the Panama Canal. And so basically what somebody said earlier this week is for 21 million man-hours, what we've done, rather than connecting two oceans and creating a huge economic engine, the only thing we've united here is lawyers and billable hours. And so I think the importance of these cost-benefit analysis can't be overemphasized, and you must comply with the law, because we're giving the American people a lot of regulations, and we're not, sure it's going to fix all of the issues that many thought that were a part of the crisis in 2008. But the other issue is the huge burden that it's going to put on the economy and the financial systems in total. And so what is your response that you committed regulatory malpractice?
I'm very proud of the agency's work, the Commission's work, and I think that we've fully complied with the Commodities and Exchange Act and the Administrative Procedures Act
On cost-benefit considerations, we take them into consideration each of our rules. The chief economist's office has to sign off on any rule that comes before us. And in many of our internal deliberations, it's really very helpful what commenters have come in and said to us about this.
But what's your response, though, that your own lawyers admitted they had not crunched the numbers when analyzing the impact or any of the alternatives to that?
I was at the same hearing, and that, with all respect, what they said was to a very specific question about, as I recall it, quantities, specific numbers on the ability to search voice records. One question, Congress mandated that voice records be kept. And in our proposal, we said that it had to be put in electronic form. A lot of people didn't like that. So we then said, okay, you do not have to put it in electronic form. We rolled back. We dialed back because of the cost of that. But we said you still just need to be able to search it to find a key term. You know, if there's an enforcement case later, that somebody's got to be able to search it. And there are readily available search tools just to be able to search and find a key term.
So you have a definitive document that says cost-benefit analysis for this rule, and it's got qualitative data in it.
Well, it's actually called cost-benefit considerations because that's what the statute.
So there is.
Yes. Oh, yes. That's in each of our rules. Absolutely.
Can you furnish me with a copy of that?
Sure, we will do that.
Do you understand the importance of why this cost-benefit analysis is important? Because it's not just what you're doing at this commission, but it's what's going on across the whole spectrum of, and what we're already hearing is in many cases there's duplication, there's conflicts of what rules that are being put out by you and other regulators, and so it doesn't appear we're moving in a direction that's necessarily positive.
I not only understand it, I have found it very, very helpful, not just commenters' views on costs and benefits, but our own deliberations when somebody in their chief economist office says, well, how do you justify this? And so now it's only within the discretion we have, but like this example of voice recordings, we said, no, do not put them in electronic form.
And is the cost-benefit analysis that you do, is that done prior to releasing the rule or before the rule is final?
There's a cost-benefit in it. Consideration section that's in a proposal. We ask commenters to comment. We particularly ask them if they can send us quantifications. A lot of times we don't get quantities and numbers as well. So it may not be as much quantification as any of us would think about in keeping our own bank account or something. But yes, we get comments through our roundtables, through our meetings, and then we include that in the final as well.
The feedback I get is that basically the quantification comes from the people commenting that your documents, the rules themselves, don't really have very much of a concrete quantification or justification of the cost-benefit analysis, and that you ask for additional information on that aspect. But the problem with that is then you take that into consideration, then you go out and put the rule. I would submit to you that if you don't have the data, you're asking for the data, that when you get that information back, that you resubmit the rule with an updated version of the cost-benefit analysis, so that then there could be comment on that. But if you're mining a lot of data from the people on comment, not everybody has the eyes to get to see that prior to when you finally resubmit, or if you don't resubmit the rule, then it's kind of done after the fact.
The good piece of the process of every agency and ours as well is everybody gets to see everybody else's comments. So we actually get comments on comments, and we've used our discretion to allow people to put in late comments. And often it is on cost and benefits, and they've been very helpful.
Gentleman's time has expired. All time has expired. Any closing comments from the ranking member? Seeing none, Chair simply notes once again, we appreciate the opportunity to look over Chairman Gensler's shoulder. We'll continue to do that as we work together to make sure that good policy is crafted in this process.
Could I say, Mr. Chairman, I would hope that even when we do finish the rules, that we would keep coming in front of this committee, but if you were trying to give us a motivation to slow it down more so that it can always have a reason to come in front of you.
Chairman Gisler, you're almost like a member of my family. We've spent so much time together, and like all family members, you'll always be welcome.
Right, thank you.
Finish this process.
All right.
With that, under the rules of the committee, the record for today's hearing will remain open for 10 calendar days to receive additional material and supplemental written responses from the witnesses to any question posed by a member. This hearing of the Committee on Agriculture is adjourned.